respective organizations are responding to the COVID-19 crisis. Finally, if during Q&A the facilitator invites comments or input from the floor and you would like to speak, please raise your hand using the tab at the bottom of your screen, and once invited to speak, please unmute yourself. On that note, please ensure that you all remain on mute for the duration of the session to avoid any background noises. My understanding is that the system automatically mutes participants, but just in case, please double check that. At this point, I'd like to hand over to Employment Law Doyen and Head of Dispute Resolution at Bowmans, Chris Todd, who will be facilitating this morning's panel discussion. Over to you, Chris.
Thanks very much, Simon, and a very warm welcome to all of our participants. I think this is a sign of extraordinary times. I don't often talk, and I don't think the panelists often talk to a group this size, and we certainly don't often talk to a group this size without being able to see all of you and exchange expressions and engage in the way that we are most used to doing. But that said, we are in extraordinary times in part because I don't need to tell you, we are experiencing and are right either on the cusp or the middle of an unprecedented global economic crisis. It confronts us with extraordinary challenges as human beings, as professionals, in our business lives, in our social lives, and family lives. And so it's not surprising, I think, that in our businesses, where we are concerned fundamentally with people, we are concerned with people who are at the heart of our culture, at the heart of our values, and also at the heart of the economic value, or our economic value, the economic value in our businesses. And that leads to a really central dilemma that I think is probably the main reason why so many of you have joined us to have the conversation we're having today. And that is, on the one hand, we aspire to, maybe many of us succeed in being employers of choice. That means really being engaged, valuing our people, demonstrating all of the kind of care and concern that keep people engaged and successful in our organizations. And on the other hand, we run businesses, which in the current crisis have run into, for many of us, for many of our clients, very serious headwinds, and even potentially ruinous headwinds if we don't navigate them properly, if we don't make the right decisions and exercise judgment. So I think in South Africa, we've never had a shutdown like this. None of us can advise on the basis of our prior experience of a shutdown of this kind, or a lockdown of economic activity on this scale. And I think that's obviously not only a phenomenon that we're experiencing in South Africa, it's an experience, it's a new experience for everybody across the globe, the particular situation that we're in. So how do employers who have these kind of competing aspirations, commercial aspirations and aspirations to treat their employees in a way consistent with their values, how do you react? What can employers do to react to the situation? What should they do? And for us, we are lawyers, of course. What is the legal framework against which employers have to decide on the kind of delicate trade-offs that have to be negotiated or decided on by employers? So that's the subject of the seminar. Simon has done most of the housekeeping. We set aside an hour for it. I do want to try to leave time for Q&A at the end, but you will appreciate with close to 500 people on it, it's going to be tricky to be able to deal with all of your questions, but we have had the benefit of quite a lot of engagement from participants prior, and so we hope we will deal with as much as we can during the session. But then let me briefly turn to who we've got talking on our panel today, Talita Loubser. I think I will just call her a recognized thought leader among her peers and other firms in this area, and she has been extremely busy in the past while trying to help organized business to bring some order to a fairly chaotic, perhaps understandably chaotic set of urgent regulations that have been pushed out, and that all of us and all of you will be really struggling to keep track of. So Talita has been very closely involved in all of that, and we're delighted to have her on the panel. Lusanda Rapulu, who is the head of our employment and benefits practice. Lusanda, apart from being an experienced advisor in all range of employment matters, is now very successfully marshalling the sometimes unruly resources that we have as a firm by heading up the practice, and by consensus, the general consensus, is doing a marvelous job. Then we have Lenya Dams Jensen, a senior associate in our practice. Lenya's got many achievements, but one of which is being the co-author of the legal authority on social media in the workplace, but also, and of importance for us today, a specialist in pension and benefits, and that part of the employment relationship. And then last but not least, she's in my top left corner. I don't know if that's for everybody, Aniria Bauer, who is our tax guru for the day, somebody who knows pretty much everything I think that one needs to know about employees and tax. So those are the people that we have to talk to you today. Let's kick off and talk, I think, first with Talita. Talita, the real question really to set the scene is, what is the situation facing employers in the context of an economic lockdown? Is this an employer-driven thing? Do we read our contracts of employment to work out what impact this has on relationships between employers and employees? And how should employers just understand the basic legal situation that they're facing?
Good morning, everyone. Thanks, Chris. Yes, I think it is important to read your employment contract and the legislation. And when we go back to basics, when there is an employment relationship, the employee works, so the employee renders services, and the employer pays. So that is the quid pro quo. Our law recognizes that this doesn't always work this way, and there are recognized circumstances in which the employee doesn't work, but is still entitled to be paid. So if the employee is sick and needs to recover at home, the employee can take sick leave and the employer will continue to pay under our BCA. If the employee's child is sick and the employee needs to look after that child, the employee can take family responsibility leave. And if the employee needs a break from the stresses of work, the employee can go on a holiday and take annual leave for that purpose. And there are other circumstances also in which an employer can say, I don't want you to be at work. I need to investigate certain allegations of misconduct against you, so I am putting you on suspension. I'm suspending your obligation to work, but I am continuing to pay you in order to enable me to investigate these allegations. And then sometimes there are circumstances in which an employee doesn't work and the employer doesn't pay, because that is the basic premise and that is the default position, because we said pay is dependent on the employee's ability and willingness to tender work. So if an employee goes out on strike, the no work, no pay principle applies. And there are other circumstances also that our legislation recognizes, and that is maternity leave, for example, under the BCA that's unpaid from the employer's perspective. So normally in a situation where the employer requires the employee not to be at work, or in a case of recognized leave like sick leave or annual leave, there is still that obligation to pay. But here we are dealing with a completely new situation. It is unprecedented, as Chris mentioned, and it isn't because of the employee's desire to sit at home, and it's also not because of the employer's desire for the employees not to work. It is an executive order from our president that employees must be at home so that we can stop the spread of this virus. It is a response to a public health crisis. And that then raises this issue of, must the employer continue to pay, or will the normal principle of no work, no pay apply? And in this whole situation, there has emerged 3 categories of employees. Under the regulations, there are businesses that provide essential goods or essential services, and they are continuing to operate. And those employees who are continuing to work must, of course, be paid. So that is easy. Then there's the category of employees who can work remotely. They have the technology and the tools to sit at home and still be productive, and they must be paid. And then there's the category of employees who cannot work remotely or who are not in an essential service, like a pilot, for example. I think we are still a way off from pilots sitting on the ground and remote controlling the aeroplanes. But those really are the 3 categories. And our challenge is in relation to employees who cannot work remotely and who's not in an essential service, and what must we do with them? So if we go from the premise that employees only get paid or are entitled to be paid when they tender their services, willing and able, and here they're not able. If they were to come to work, they would be breaking the law and could be put in jail, frankly. What do we do with them? So the premise is no work, no pay. So the employer may want to introduce mitigating measures in order to address that hardship that may arise. And the employer can do so either by paying the employees, if it can afford to do that, or it can pay part of their salaries, if it can afford to do that. Or under the BCA, you can require as an employer when employees should take annual leave. So you can require them to take annual leave now. And in that instance, it is really the employee bearing the cost of this lockdown period. And then in the last instance, the employer can potentially offer a loan to employees that might be recovered in due course. And each of those carries with it its own challenges, but those are mechanisms in order to mitigate the hardship on the employees that they might face now. So I'll stop at that point.
So the basic, if I was going to build it from the ground up, you're saying that employees who are unable to work because by law or regulation they're not allowed to turn up for work don't have a right under their contract to be paid because they're not at work. And from there, you've described a number of scenarios in which employers can mitigate that consequence, partly comply with it, and so on. Okay, now that's a very useful. I mean, one of the questions that has come up, and it's perhaps not surprising, although it's not fully understood, the trade union movement, at least through the mouthpiece of COSATU, to have said employers should not force employees to take their annual leave. In those, from what you're saying, that leaves employees at risk of being unpaid as opposed to on paid leave. I don't know if you've got any comment on that or whether there's been any evolution or development of that kind of debate.
Yeah, I think that there is a recognition that the employer may determine this period as a period of unpaid leave, even by the unions. They are just saying the employers shouldn't do this because this is not the employee's fault. And that makes it really a collective bargaining issue. The legal position is that you can require employees to take during this time. And there's also benefits afoot through the UIF, which we will cover in due course. And, you know, the minister has also come out and said, you know, the employers can require employees to take leave now, but, you know, it is really preferred that they make use of the benefits through the UIF structures. Now, you know, it is debatable as to whether that is better for employees or not, because if employees are on leave, then all their pay and their benefits remain intact. If employees suddenly find themselves in a situation where they are not paid, it raises questions about medical aid contributions, pension fund contributions, and a whole host of problems. So I personally think that requiring employees to take leave in this time is a very good mitigating way, but that might also not be possible if the situation is going to continue. So that is quite a tamalegi.
So a couple of questions I'm going to deal with quickly that come up from what you've said, Talita, and I don't want to keep you on the spot, and we will obviously move to the other panelists in a minute. But one anonymous attendee is pointing out that someone might have resigned and be serving their notice when the lockdown kicks in. And the question arises, well, what happens then? You were paying them for their notice period, and how is that impacted? The second question that Inge Langerskafni raises is, what about public holidays? I don't know if we've had any public holidays yet during the lockdown, or whether do we anticipate any? Yes, of course, we will have some coming up. And then the third question, just to make sure you're on your toes, Talita, does leave accumulate during a lockdown period?
Okay, let me start with the leave accumulation one. If the employee's contract says you're entitled to 15 or 20 days leave during an annual leave cycle, then it's irrelevant whether the employee is working or entitled to be paid. The entitlement relates to that annual leave cycle, and the employee's leave will accumulate during that time. The BCA also makes provision for a different way in which you can regulate the leave entitlement, and that is to give the employee the entitlement to 1 day's leave for every 17 days worked, or 1 hour's leave for every 17 hours worked. And it has this interesting addition in the BCA that says 1 day for every 17 days worked, or on which the employee will be paid. So in those circumstances, the employee wouldn't be working, and the employee would also not be entitled to be paid. And arguably then in those circumstances, the leave would not acquire during the lockdown period. So you really need to read your employment contract in order to see where you stand on leave. So now on notice, yeah.
Let's apply the same provisions and say if you were going to be paid during your notice period, and you were going to be working it,
yeah,
and now you work, I suppose the no work no pay applies. Of course, if your working requirement was waived and you were sent home with your notice pay intact, then I don't think the employer could recover it.
Yeah, agreed.
I don't know if we left any. Was there a third point you were going to come to, Talita, or have we dealt with those? I'm wanting on to Lenya and talk about essential services. Maybe we can come back to those if we want to. Lenya, Talita mentioned and we all know that there have been these gazettes of a set of what are now described as essential services for the purposes of these emergency regulations. And then some of them obviously overlap with our traditional concept of what are essential services, providing healthcare, for example. Supermarkets have never previously been considered or described as essential services, the provision of food services. What do we make of that distinction, and what do we make in particular, because we know from our business it wasn't very long before we had threats of or actual industrial action in different categories of essential service. Can you just share with us what we are to make of this kind of idea of essential services and the new essential services?
Sure. So for purposes of the Labor Relations Act, because as you said, it has a very specific meaning. So the Labor Relations Act designates as essential services the South African Police Services, parliamentary services, and then importantly, any other type of service that is designated as such by the Essential Services Committee. So what that means is the Labor Relations Act provides definition of essential services, but it's ultimately left to the Essential Services Committee, acting under the auspices of the CCMA, to apply that definition and to determine what is and what isn't an essential service. So for labor relations and strikes specific reasons, it has a very specific meaning within the context of the LRA. But now what's happened is under the Disaster Management Act, as we've said, there's been a whole list of annexures and businesses that have been listed as essential services. And even though there is an overlap there, they've been designated as essential services for purposes of the Disaster Management Act. There's no reference to the Labor Relations Act in that. And your example to go to the food, the food services, which is now for purposes of the lockdown designated as an essential service. The main question is, can employees go on strike during the lockdown? Because as most of us would know, if you're on essential service for purposes of the LRA, you're prohibited from striking, and you have to resolve any matters of mutual interest disputes by arbitration. So we've thought about this a lot, and what we think, the view that we've adopted is that even if you're classified as essential services for purposes of the Disaster Management Act, because the Essential Services Committee hasn't made a decision or promulgated a list of your being an essential service for purposes of the LRA, we think those employees that are now designated essential services during the lockdown still have a right to strike. So they wouldn't be prohibited from striking unless they are deemed to be an essential service in the ordinary course under the Labor Relations Act and by the Essential Services Committee. So what this means is that, yes, they would be entitled to strike, but insofar as they do seek to strike, they would still be bound by the provisions of the LRA. They would need to refer disputes to the CCMA, and the time periods prescribed by the LRA would need to be exhausted. They would also need to give proper notice in terms of the LRA. And of course, the interesting, scenario here is that even if they do ultimately embark on what is known as a protected strike, they're locked down, so they're going to have to strike from home. They wouldn't be entitled to, engage in demonstrations and pickets. So really, what the force or effect of that strike is for the employees is questionable. And of course, if it is a protected strike, the employer would be entitled to engage replacement labor. And then the no work, no pay principle would also apply in those circumstances.
Thank you very much, Lenya. Yeah, the idea of a strike in the absence of any picket line is difficult. It's theoretically possible, but as a matter of sort of organizational history, and I've certainly been told this by many trade unionists, that at the heart of a strike organization is the ability to assemble and collect and debate and debate strategy. So I can imagine it would be very difficult to maintain, for a union to maintain industrial action during this period. Can I move on to you, Lusanda, and ask a question which actually arose from some of the attendants asking pre-questions, which is, if we follow Talita's proposition that workers who are able to work from home and to continue production and continue to do the work that they're hired to do will continue to be paid, or will be entitled to continue to be paid. By contrast, those workers who can't work from home because their production or their jobs are fundamentally associated with the factory or the plant or the office where production takes place, and they're now precluded by law from leaving their homes. That leads to a situation which doesn't sit very well with blue-collar workers, low-paid workers who say, hang on a second, it's the middle management, clerical workers, middle management, that are working from home and still getting paid, and we sit at home without any ability to work from home, and we aren't going to get paid. What do we say about this? Is this law? Is there any law in this? Is this just something that people have to suck up, or is this something that's going to just feed into employer strategies around maintaining morale of the workforce and holding the business together?
I think it's a difficult balance, Chris. On the one hand, we're looking at business imperatives. We're looking at those people who are able to work from home and who are crucially required to continue working for business continuity and sometimes for the survival of the business, versus those who actually may not be required to work. As you say, some people's jobs are intrinsically linked to the business premises. For example, if you're a cleaner, if you work in the canteen, so actually your services are not required, and therefore you can't work from home. So we balance that, the business imperative and the operational need about actually who can work from home and who's required to, and who can't and actually may not be required to work for business continuity during this lockdown period. But of course, we are dealing with organizations, with culture and values, and we say we value all our people and everybody's important and every job is necessary for the work to continue. So those values remain important, and our workers within our various organizations are watching and saying, how are we being treated in difficult times? And I think that's part of why there's a call to exercise some compassion, understanding that there are those who are highly affected, and those are often those who most need actually to be working, who most need the pay during this time. And I think that's part of why government is saying, please, to the extent that you talk your workers, please take a long-term view of your organization. So it's a balance between
So we've temporarily lost you there, Lusanda, but I was going to talk, just picking up on that point. I saw Carol Payton published an article in the Business Day today, which reflected a statement put out by Organized Business, by BUSA, which I think they used the word generosity and said actually they would like their members to exercise a degree of generosity. I think that is partly in the context also, though, of attempting to negotiate what uninsurance benefits are available, and that's something that we're going to come back to. I think it's a question that a couple of people have asked. But Lusanda, if we could just check if you are back online. There's another topic that I wanted to press you on, which is this. Things don't always go well with employees. We can make lots of encouraging noises about employees being at the heart of our culture and key to the value of our business. But the question that is on some people's minds is, how do we manage performance of employees if they are working at home? I assume we can't manage any performance when they're not working, because there's no performance to manage. But how do we do this? And what about discipline? Because some employers, rather like the question asked, what happens if someone's given notice just before the lockdown? Well, the employer might have given notice of a disciplinary process just before the lockdown. Does all of that go on ice now until the president tells us that the lockdown is lifted, hopefully at the end of 3 weeks, if not some further period? So is the recalcitrant, poor performing, poor behaving employee now get a pass for the duration of the lockdown?
The question of measuring performance, I think there are various things that employers can put in place. I think employers can set specific deliverables during this lockdown period, and for the employees to know that these are the deliverables during this period. I think there are ways in which employers can measure their performance, such as requiring employees to complete timesheets, require employees to email them, telling them what they have done, what they haven't done. They could set up weekly calls with their employees and actually have conversations with their employees and check on the performance deliverables and check what is being done and what is not being done. So I think there are various practical measures that can be put in place to measure performance, despite that people are not physically in the same space.
And can we run disciplinary hearings, Lusanda? Do we continue with this? Do we continue as normal with our disciplinary processes?
So our primary guide would be the company's disciplinary code and procedure. And for those companies where the disciplinary code and procedure allows for some flexibility in how discipline is conducted, it's easier for them because they can then put that flexibility in place. They could have disciplinary hearing through Zoom. They could have it purely telephonically. Their disciplinary code would give them that leeway. For those whose disciplinary code does not give them that leeway, they would have to make a decision about whether to park the process or take the process forward anyway, using the technology that's available and taking this as extraordinary circumstances, that if challenged, that process was not in line with the disciplinary code and procedure, they could substantiate by saying that these are extraordinary circumstances that warranted that to proceed. And I think particularly in respect of urgent matters, I think that justifying why the process urgently needed to proceed and couldn't wait 3 weeks could be something that could be used to substantiate why you proceed, despite the fact that your disciplinary code is quite stringent and doesn't have the contractual leeway.
That's very interesting, and I've got a feeling, Lysanda, that when we do emerge the other side of this crisis, and although this might not be our biggest topic, we may also be talking about ways of using and living very practically without this, what has become a rather archaic kind of ritual of formal disciplinary hearings in which we emulate some kind of television show of court trials that we've seen on TV. But anyway, that's a topic for another day. And Neri, I want to bring you in here if you can, because we've heard from Talita about all the different sort of possibilities that employers are facing in terms of deciding whether and how much to pay employees in different categories during this period. Why do we care about tax? Where does it come into it? Why does it matter to employers? How are there differences in how these different forms of payment are taxed? And I think you will probably touch on, if you answer that question. I heard Talita mentioning you could even advance payments in the form of a loan rather than salary. And does that change the tax position? Can you help us?
Thank you, Chris. The reason why we care is because SARS cares. SARS is obviously trying they need to raise money for the running of the country. And I must say it's been very encouraging to see the measures that the government is trying to implement in order to accommodate businesses and in order to keep the economy going. The two main issues that I just want to touch on this morning, or the two main groups of issues, is the one, to the extent that you provide specific benefits to employees, what does that mean from a PAYE perspective? Are some more beneficial than others? And the other is for those employees who are having financial difficulties, what support has SARS or government via SARS offered? And maybe let's deal with the latter first. So for employees who are struggling financially in this period, those companies with a turnover of less than 50 million, they get a reprieve or some reprieve from a PAYE perspective, in that they have to pay only 80% of the PAYE during the period April, May, June, July of this year. That 20% is not waived, but it will be, it will have to be paid, settled over a 6-month period, starting with the first payment on the 7th of September. There's also some relief in the form of the employment tax incentive. And what makes that quite attractive is that the employment tax incentive can now be claimed also for employees who would not normally qualify. Normally, your employees have to be between 18 and 29, and you cannot claim ETI if you have already claimed the benefit in respect of them for a 24-month period. Even for those employees, if they earn less than 6,500 Rand, one can essentially claim 500 Rand per month in terms of the employment tax incentive. So that can actually put some cash back in the pockets of employers. The other issue to consider, and we've been talking about employees working remotely. I've also seen one of the questions dealing with expatriates. There are quite a number of practical issues. And I think one of the ones which comes first to mind for those employees who are working remotely, but who do not work remotely on a regular basis and who now have data needs. They need to buy data, they've got extra cost of telephone calls, etc. How do you deal with that? And one of the important issues there to remember is that if you provide an allowance to an employee for the use of a cell phone or data, that is taxable. And you don't want to add insult to injury by giving them an allowance to help them with data costs and then to tax them on it. So it's very important to do it as a reimbursement. You can do an advance, but then they have to provide you with proof of the expense. And you would need some or other mechanism to show that they actually used it for business purposes. What we are implementing internally, because it is so difficult to measure the use of data to see, was it to keep your kids busy watching Netflix while you're working from home, or was it for you to actually do business work, is Bowmans has formed a view as to what the general data requirement is per employee. And that will be used as a measure as to the amount to be provided to those employees who need it. And their managers would also need to sign off and say they were actually productive and busy during that period. It's very important to have that kind of policy. There are also those employees who still need to come to work, and they may need some financial assistance. So for example, if they are relying on public transport, it would be a lot more difficult to rely on public transport during this time. To the extent that they receive any financial support, one would also need to look into that to see that it doesn't create an additional tax burden. There was a question about expatriates who rely on the foreign earnings exemption. And one of the big questions for expatriates is, are they still going to qualify for the exemption? They need to spend 183 days per year offshore, of which 60 days must be continuous. And currently there is a prohibition on travel. So they're stuck. So actually from a pure tax perspective, it's better if they're stuck in a foreign country than in South Africa, but that is obviously not ideal from a social and a family perspective. There's no yet indication as to what SARS is going to do in that regard. Whether there will be any relaxation, that must just be monitored on a continuous basis. Employers must also just have a look or keep an eye on other benefits. So for example, if some of your employees receive a car allowance, is it necessary to adjust that? If they received subsistence allowances and they can't travel, just remember to include that in their taxable income. So essentially just be aware of the potential issues and just keep monitoring them.
Thank you very much, Aneria. Talita, I've been monitoring the questions that are coming in, the Q&A, and there are quite a few that I think mean we have to come back to you. And I want to talk about UIF. Quite a few of them do raise that. But before we do, we skipped the question of public holidays. Do you pay for a public holiday that falls during the lockdown? Do you have a straight up answer, or are you going to duck it?
I was hoping I'm going to duck it, but I did make a note of it. So on a public holiday, an employee is not required to work. They can be off, and that is paid. And the Public Holidays Act also entitles the employer to exchange that day for another day. So either I think you would still pay for that day, or you would tell employees you can take your 2 public holidays later on in the year and exchange it for Easter, the 2 public holidays that we see there.
The basic, if you have to, we just applied your basic proposition, which is if the worker can't come to work, they're not tendering their services. Well, on a public holiday, they're not required to tender their services. So you can't say you're not doing something that I expected you to do, and consequently assume pay, the normal consequences would follow.
Yeah.
Quite a lot of questions have come through about, this is for you again, Talita, the question of being allowed to pay short time. I think a large number of employers are experiencing a position here where their productivity, and these are employers employers have either had to shut down their operations completely, or they are able to maintain some degree of functionality through remote working. But what they want to know is they say we're effectively paying full value of a workforce that we'd only be able to deploy half or a third. Can we put staff on short time? Can we lay off temporarily? Can we temporarily reduce pay?
Yeah, I think the answer is that they can. And there was an amendment in 2016 to the Unemployment Insurance Act in terms of which benefits for short-time workers were made available. So that is something that they could then look into. Employers who do not require employees and employees who cannot work in this time may also be able to claim what they call a C19 TERS benefit, TERS benefit. And the detail of that benefit is still being fleshed out and negotiated at NetLag. But as we understand it, employees who are not paid or who are paid only a portion of their salary would be entitled to claim that benefit. And actually, it's not going to be the employee that claims the benefit, it will be the employer that claims it. And what is being discussed is payment by the UIF of those benefits into the employer bank account so that the employer can then distribute the benefit to the employees. And I must just stress at this point that there's been some confusion about the actual amount of those benefits. In our interpretation of the directive, which is also currently under review again, employees would be entitled to the minimum wage, either the minimum wage or the minimum wage that is determined for that sector. And that would be compared to what they would be entitled to in accordance with the sliding scale, measured as a percentage of the BCEA threshold of 17,200 roundabout. So not all employees would get the full 17,000. In fact, no one would, because it goes from about 38% to 60%, and that is the threshold amount against which you would probably have to calculate it. So it isn't a case that employees will get full pay through this benefit. And an employer will be entitled to up that benefit so long as what the employee is ultimately getting isn't more than 100% of their salary. So they can get a contribution from the employer and then a contribution through this special benefit. The exact details of that whole system is still being fleshed out. But yeah, you know, that is aimed at assisting employers that cannot pay during this time or cannot pay full wage, can only pay a portion of the salary.
Well, that deals with quite a few of the questions that arose. Ernst de Toy, you called Talita out for not answering the public holiday question, so I hope you will see that we are no pay applies, but I think that's something, I don't know whether we can take that any further. Quite a lot of people talk about force majeure and questions like that. I seem to have having complaints that my internet connection has been interrupted. Is it okay? But I think we might have to leave that to debate for another day. I understood Talita to say the basic proposition is if an employee can't get to work for reasons even outside of the employee's control, it's not, there isn't a reciprocal obligation to pay, because whether it's the employee's fault or not, they haven't actually been presented themselves for work. So you might not fire them for absenteeism. Of course, you can't do that, but they haven't been able to deliver their basic side of the bargain, which is to work. And so I want to just move onto a different question now. Again, back to you, Lenya. Quite a few people have asked about duties to maintain medical aid schemes and pension fund benefits during this period.
Yeah.
Obviously, my concern for employees who think or are told either that their employer is going to pay nothing over this period and they must rely on UIF claims, or who are told they'll be part paid. I don't think in my experience that you can part pay a medical aid contribution. So how do employers approach this problem of, are they able to suspend medical benefits? And I suppose that's a particularly sensitive one, because right now, of all times, employees are wanting to make sure, if they're lucky enough to have medical aid benefits, that they maintain them.
Definitely. So there have been lots of calls to the regulators, such as the Financial Sector Conduct Authority and the Council of Medical Schemes, to basically alleviate, take steps to alleviate with the challenges that financially distressed employers and employees are facing, particularly within their ability to make contributions towards memberships of various schemes. So in the past few days, the FSCA and the CMS, the Council for Medical Schemes, have been responsive to these requests. They've issued certain communications and circulars, but we're still waiting for further guidance on those. But to your question, we're basically dealing with two specific scenarios. So the first would be is where employers have agreed with their employees to reduce salaries and reduce pay. And the second is where you've stated where you're dealing with temporary layoffs or no work, no pay, and absolutely no remuneration is coming in. So obviously the starting point for both of those situations would be that you would look at the contracts of employment. You would also look at the wording of the policies in place and the rules of the scheme. So that would be your starting point. But specifically in relation to reductions in pay, that situation is a bit more simple. So if you think of group life cover, this is usually a function of a multiple of a salary. So if you reduce the salary, that would equate to a reduction of the amount of life cover provided. So you'd be okay there. With the disability benefit, again, it serves as an income replacement mechanism. So again, a reduced income would result in a reduced monthly payment. So again, as long as there's money coming in, a proportion reduces. Retirement fund contributions, as you'll all be aware, are expressed as a percentage of the salary, and so reduced pay would again just amount to reduction in the contribution rate. But here, what the FSCA has specifically stated in its latest circular is that if the rules of the scheme to which the employees belong don't make provision for a reduction of payments or contributions, then what funds are required to do is urgently effect rule amendments and submit these to the FSCA for approval. So it's basically deal with those interim measures where there aren't anything in place at the moment. And then with regard to medical aid, as you said, Chris, we can't, proportionately reduce contributions to medical aid unless there is an option, that the actual schemes introduced to downgrade your membership during this period, which we haven't heard from yet. But largely with medical aid, what we would propose is that if employers are reducing the salaries, what they do is reduce the cash component, and then they still keep intact the medical aid deductions and remittances every month. Now, the position with temporary layoffs gets more complicated because no remuneration is coming into play. So in relation to group life and disability insurance, that would depend ultimately on the wording of the policy document, and employers would need to engage with the insurers on how they can actually manage that in the interim. If the group life benefits are linked to a retirement fund scheme, then ordinarily the rules of the scheme would provide that a temporary absence wouldn't result in a lapsing of the group cover. But again, you'd have to look to the rules of the policy to consider this. As I've stated, with retirement funds, there are contributions as a function of remuneration. So they would stop if you're not being paid. But as I've stated, what the FSCA is saying is that if you guys don't have, if the rules don't deal with these provisions of temporary absences or stops in contributions, you need to effect rule amendments in order to deal with the scenario and mitigate the impact on employees and members. And insofar as medical aid is concerned, we've adopted the view that the first prize would be for the employer, and Maria has already touched on this as well, is to strike some sort of arrangement where the employer undertakes to continue making those deductions and remittances, and the employer and employee agree to a mechanism by which to recover those payments in the future, hopefully when things recover. But what we've also shortly debated this morning, and obviously we're still forming a view on it with the temporary employee relief scheme that's being debated, is if UIF or these benefits in terms of the temporary employment relief scheme are being paid directly to employers, whether they could use a portion of that to pay towards medical aid. And our view at this stage is it really depends on the wording of the regulation. So if the regulations ultimately come out and they categorize that benefit as a form of remuneration, then we think you could still be making the contributions and deductions in terms of Section 34 and 34A of the ECEA. But if it doesn't seem to amount to a type of remuneration, then there you need to look at reaching agreement with your employees. It is coming into your financial systems that you continue to make those deductions on their behalves. So there are a lot of options and a lot of variables, but largely it's with reference to contracts of employment, existing policy documents, and the rules of the schemes at this stage.
Thanks very much, Lenia. I'm in charge of monitoring time, and I see that we're into our last 5 minutes. Difficult to deal with all of the questions coming through. One of them is, I can flip it to you. Some people either were already in pre-existing retrenchment processes or anticipate them right now. We talked about disciplinary hearings, but is there any reason why you can't consult with employees, whatever you want to consult with them about, using information technology like this? Can you consult by telephone, by Zoom, and can you pursue a redundancy or retrenchment type of consultation through this kind of digital engagement?
Absolutely, Chris. I don't see any reason why you can't continue with such an exercise, especially if you've already started the exercise, you've issued the 189.3 letters, you're consulting. The LRA requires you to consult. It requires you to go through the different consultation topics and to genuinely try and reach consensus. And there's no format in the LRA in how that's done. So absolutely, there's no reason why you can't continue with your retrenchment exercise.
Thank you very much. The questions come through from Annelies Skuman. Is the UIF benefit paid to employees going to be taxed? I don't know if that's something you can deal with, an area. I think, or Delenia, did you deal with it and I wasn't listening? And then deal with that already.
It's an interesting question because normally your UIF benefits are specifically exempt. We need to wait for the draft bill to come out today or tomorrow. This is, I mean, it's really, this is uncharted territory for everyone. So there are lots of tricky issues, and one of them is because these payments will be made to the employer. Is the employer simply a conduit? Is it just from an admin perspective that it's paid to the employer and the employer will unpay it as a UIF payment? Or is the employer paying it as remuneration? So currently the normal principle is if it is UIF payments, then it's exempt, but we'll need to see what happens in the regulations.
A great point that needs to be incorporated in the regulations. Talita, I hope you're making notes there.
You too, please.
A related question, Gareth Dunn. I'm not going to read what your question, I think you should read it yourself. You sent it at 11:18. But the question really is there, do we know yet whether the regulations are going to provide for UIF benefits for a partial shutdown or only for a complete shutdown of a business? And maybe, Talita, do you want to pick that up?
You're welcome. Yeah, the proposal is that it will also be for partial closures, not just a complete shutdown. But we don't know yet.
I think that is very much work in progress, and I think the role players are hoping that there will be, agreements finalized and announced in the very near future. So that's one of those. I
perhaps pick up on one of the questions that was, can I retrench people telephonically? And we've discussed the consultation being done through electronic means and on telephone. There I must just also caution that it needs to be meaningful consultation. And sometimes employees listen to what other employees are saying in the consultation meetings, and we must just make sure that those groups of employees that we consult with are the right groups. But then on the point of giving termination notices, the BCA says you must give notice in writing. So that will, you can call employees and tell them, we've done our retrenchment consultation and sadly, unfortunately you are going to be retrenched. But the actual notice of termination needs to be in writing. So that needs to be either by SMS or WhatsApp or email.
Talita, one quick one that's come through, and I don't want to prolong this, but quite a few people wanting to know what happens if employees say they don't want to come to work, even though, so whether assume it's an essential service, other employees might not be entitled to. But they say, I don't want to come to work because I'm afraid of the public health consequences, but I still want to be paid.
Now, I think if you are running an essential service, you are entitled to require employees to come to work. And if they don't want to come to work, that is a breach of a reasonable instruction for which you can discipline them. They don't now have the choice to sit at home and be paid or to come to work. They must come to work. And if they are saying they are afraid because of the public health crisis, your duty as an employer is to ensure a safe working environment. If it isn't safe, it is a breach of the Occupational Health and Safety Act. And yes, there might be a heightened obligation to ensure safety in these circumstances. So that is why at the SPAR, at the Pick n Pay, you will see the security guards with the hand sanitizer and the trolley wipes, and all of those things are provided. But I don't think that an employee can say, I want to sit at home and be paid and not come to work because I'm now so afraid, if the employer has the correct safety measures in place. If it doesn't, then under the Occupational Health and Safety Act, the employee can refuse to work.
So with the permission of the assembled cast, I know that participants might have, we pigeonholed an hour. We started 5 minutes after the half hour, so I'm proposing to continue for another 3 minutes so that we can just try and run through a couple more questions. One of the questions that somebody asked is, what happens if we've just offered someone employment thinking that it was business as usual and they're about to start, and now it turns out that we don't think we need them after all because of a catastrophic decline in our business? Are we dealing with them any different from a normal retrenchment scenario? Are they employees once they are about to take up work? Lou, do you want to pick that up? Talita, any of you come in? Maybe Lusanda?
Once the employment contract has been concluded by both parties, then yes, it's in force. And in order to terminate the employment contract on the side of the company, if they now decide they no longer need that employee, then yes, employment law would apply, and they would have to follow one of the grounds in employment law in order to now terminate that contract.
But I suppose if the proposition is that we don't need this person and we genuinely don't need it, well, that is a classic case of redundancy, and the redundancy can presumably arise even before you take up work if circumstances change dramatically that in a way that you hadn't foreseen. Okay, that's very useful.
Exactly.
Then there are quite a few public that I don't think that we can deal with now. There's a question Barry Gordon Davis raises about the Section 189A, the 60-day consultation period. Quite a lot of companies will be in a position, the thresholds there are met when more or less 10% of their workforce is being you're contemplating reducing your workforce by more or less 10%. In many industries that have come off a bit of a fiscal or revenue cliff, they'll be looking at retrenching substantially more, and they might be saying, but I don't have 60 days to play with. Talita, Lenya, Talita, do you want to come in on that one? What do we do about that situation? What can employers do? Is there a short answer, or is it a long answer that we can't really?
Yeah, I love employment law because it's always this, but however. So yeah, the legislation says 60 days, but the employer and the consulting parties can agree to shorten those time periods. In my experience, employees do not like agreeing shorter time periods unless they are paid for the full consultation period. If the principle is that if you are not working, you are not paid, that might alleviate some of the hardship for the employer in those circumstances, and the employer would then not pay the employees, but just sit through the 60 days, consult properly, and then give notice of termination in accordance with the LRA. Where employers currently envisage a Section 189A retrenchment process, and either the employer or the consulting parties request facilitation, that facilitation is not going to happen before the end of the lockdown because the CCMA is closed. So that would then also put a hamper on the consultation process. But if facilitation isn't requested, the employer can consult.
Thank you very much, Talita. We've reached 5 minutes. We've gone past our 5 minutes past the hour. I think we have to call that quits. I think everybody will have budgeted that time. If I could just say thank you very, very much to the panel. Most of all, thank you to the participants for joining us. I hope we've been able to deal with the large majority of your questions. I'm aware from going through them that there's some we haven't been able to get to. Hopefully you know how to get hold of us. Kavish has just put up the contacts. I'm sure you will have ordinary points of contact into the firm. If you don't, you can write to email Lusanda, who heads our practice, our employment law practice, and she will certainly be able to point you in the right direction. So without more, thank you very, very much, and we look forward to seeing you next time.
Chris, if I can just jump in quickly, we've sent out a news flash yesterday regarding employees' tax issues. So those clients who do not receive it on a regular basis, you're welcome just to reach out to us that we can forward it to you.
Thank you very much. Thank you all.
Thank you.
Thank you. Bye.